All right, now you heard something very interesting right there. The bailiff is actually collecting jury questions. Now, do you remember a trial a little while ago? It was called Michigan versus Springer, where the jury was allowed to ask questions of the witnesses. Well, guess what? The same thing happens in Nevada. Now, in this case, the jury can ask questions of the witnesses after the prosecution and the defense are finished their line of questioning. So while the bailiff is collecting those questions, let's bring in our next guest, criminal defense attorney Barry Sorrels. He's with us right now. He represents several professional athletes, and he joins us right now from New York. And Barry, I always say I think this is a very good process because it lets the jury get involved with the questioning and really gives you also a view into, it seems, what they might be thinking of in this case.
Well, I tell you, Ryan, I practice in both federal and state court in Texas, and jurors aren't permitted to ask questions. And this is really the first time I've ever seen this in the courtroom, and my reaction, honestly, is fear. I mean, I'm scared to death of, I'd be scared to death of this process. Now, maybe I just don't know enough about it, but my main concern would be jurors asking something that would not be admissible otherwise, or put you in a position of having to offer inadmissible evidence that's been kept out by a judge. I tell you, it just causes me to feel fear to open the questions up to jurors.
Okay, I know one thing they do, Barry, in these cases is the questions go to the judge collects them, he takes a look at them, I believe, to make sure that they won't violate any rules or come in and ask the wrong kind of thing and maybe get something out that shouldn't be out there. But under that circumstance, does it give you, if you were to be in a jurisdiction where the jury could ask questions, would it maybe give you some insight into what the jury's thinking and maybe shape your case a little bit?
Well, I mean, information's like gold. The more you have, the richer you are most of the time. And in this situation, if you could see where the jurors are at, I assume that there could be some good information that you could use as far as how you present the rest of your case. So, you know, I'm caught off guard by this juror questioning, but I'm willing to make room for the possibility that there could be some good things about it. I'm just caught off guard, but I'll be more open-minded in the future on this topic because it looks like it may be coming.
Well, we're about to see what happens with it. One more question for you. One of the big questions in this case is a call that was placed to different phones, Barry. One, the defense saying it was a call that happened much later where the defendant was at a bar somewhere. The prosecution saying that this call that's coming in right now is what we're hearing about when things happened. When it comes down to this kind of evidence, is it always the proof is in the pudding with the phone calls and the footage? Is that the strongest kind of evidence you can have? Well, I mean, you know, it's the corroboration and the more links you can have that prove your case by these small facts like telephone records and things like that are very important. In this case, the defense is looking at bad facts, and obviously their theory is that our client couldn't have robbed and mugged this man because he was somewhere else. You can't be two places at once. I'm not so sure they're going to be able to nail the timeline down good enough, though. Mm-hmm. We'll just have to see. But when the ship's sinking, it's time to fire all guns. All right, Barry, let's go back to court. Wow. Guess what? There is a full-on battle going on between the defense attorney and the judge in this case. And I got to tell you, in so many different ways, I think the defense attorney may be stepping on some very thin ground. Betsy Allen, I understand the frustration. It happens all the time in court. People get mad at each other. But in this case, maybe she's stepping over the line a little bit. I want to bring back in criminal defense attorney Barry Sorrels. He's back with us from New York. Barry, answer me this question. All right. I think what the judge is concerned about is harassment in a sense of this witness by constantly trying to recall the witness, who's, by the way, an out-of-state witness. But at the same time, you had a chance to cross-examine him, and you're not even really telling the court why you need to talk to him. Well, I mean, as a general rule, one of the worst things you can do as a trial lawyer is antagonize the judge and get the judge thinking that you're going to be a problem, because judges have a tendency to retaliate. But Ryan, in this clip, I totally take the side of the criminal defense attorney. Wow, all right. Because, I mean, she doesn't know whether or not Javon Walker is going to be needed to be recalled or not. You can't anticipate what other states' witnesses are going to be saying, and they're asking that he be excused. She can't afford to just completely excuse him. There's one simple way to resolve this, and it should be by the judge, who would say he is excused but subject to recall in the event someone needs him to be a witness. This defense attorney shouldn't have to be fighting this battle. He should be available for whatever reason she needs him, unless there's some
motive just to be, mean-spirited and harass him, but I'm not getting the impression that's what this lawyer's up to. She just doesn't want to reveal her trial strategy at this time, and she may have a good reason for recalling him. We don't know. This judge, I think, is being unfair and picking on the criminal defense lawyer for no good reason.
But what about the way she's asking? Because I think that might be part of this here. You just mentioned you don't want to get on the wrong side of the judge. I agree with you. I think you let somebody be excused, you subject them to recall. But I think the problem is these comments like, you're running my case and I get to do this all the time. It's almost disrespectful, and it's kind of putting the judge in a position where, he's getting a little bit angry.
Well, that's a good point. Her demeanor, she's got the right. She's got the law on her side on this topic, I believe. She doesn't need to get upset or let the judge get under her skin. She has to at all times remain professional. And what we're seeing here is a young lawyer, in my opinion, sort of being thrown off balance and reacting in a way that she's probably going to regret later. But she's young, and everybody makes mistakes in the courtroom, and she's frustrated. She just wants to do the best for her client, and this judge is sort of wire brushing her too much. And yes, I agree with you. She probably was a little immature in the way that she responded, and she'll learn not to do that in the future.
Right, especially with this judge, especially since he's talking about sanctions. Barry Sorrels, thank you so much for your insights there.